Hey guys, welcome to this video. My name is John Watts and I appreciate you watching this video. I just want to say something real quick. I have not been on YouTube last week or two, and typically I try to put out a video every day or two, but we have been getting ready for a jury trial, actually involving the Fair Credit Reporting Act. And when you're getting ready for a jury trial in federal court, that kind of sucks up all of your time. So I apologize, I have been sort of out of pocket here, but that case has now been resolved. And this is a case, this John Salcedo, I guess is how you say it, versus Alex Hanna from the 11th Circuit. It's a case I want us to spend some time with. This is involving the Tcpa, Telephone Consumer Protection Act. And a lot of the case decisions we look at, it seems like all of them involve this issue of standing, or do you have a concrete injury in fact, or an argument under the Spokio decision. And this really hammers home because the entire case is about that. And the argument is from the defendant, hey, just because I violated the TCPA does not mean you have the ability to go into federal court. And for about maybe 2 or 3 years, I did about 5 national webinars where we were training other lawyers involving the TCPA and class actions. And I would bring up this point that, you know, there's some great advantages to filing these cases, even class action cases, in state court to begin with, so that you don't have to face this issue. And everybody was nice. I mean, nobody said, John, you're a moron, at least not out loud. But I certainly got pushback on that. And this case is what I've been concerned about, because we'll see in this case the court goes, nope, you have no right to be in federal court. So let's go ahead and look at it. And you'll see this came out very recently, August 28. And it's a very organized opinion. I don't necessarily agree with the result, but I'm not sure that I absolutely disagree with it either. It is a close question, but I will say this, very organized opinion. So here's the issue. Is receiving a single unsolicited text message sent in violation of the TCPA, again, Telephone Consumer Protection Act, a concrete injury in fact that establishes standing to sue in federal court? And the answer is no, it does not. So here's the background. We have this former client of the law firm, and he gets a text message saying, hey, 10% discount on legal services. And so he files suit, and he files it as a representative of a purported class action. So in other words, he wants to represent all the former clients of this law firm that have received an unsolicited text message. And the court points out, here's the law, the TCPA, and what the law talks about is a call by an automatic telephone dialing system or artificial pre-recorded voice to a cell phone. And while it doesn't say text message, the courts have interpreted a text message to be the same as a call. And so this guy wants $500 per text message, and then he wants it tripled to $1,500 because it's willful. And the law firm moved to dismiss for lack of standing. And the district court said, I don't agree with you, defendant law firm. I think there is standing based on this Mohammed versus off-lease case. But the judge recognized, hey, this is a close question, and technically the language is controlling question of law to which there is substantial ground for difference of opinion. And so the judge said, I'm going to allow you, the defendant, to go up to the 11th Circuit and what's called an interlocutory appeal. And so all that means is normally when we do an appeal, it is from a final judgment where the whole case is resolved. But every now and then you can go before you have a final decision. So in this case, remember the defendant said, throw the case out for lack of standing. The district court judge, a trial judge, said no. So the case is still ongoing. There's no final order there. But the judge said, I'm going to allow you to ask the 11th Circuit if they will decide this issue, because it's a threshold issue. I mean, if there's no standing, there's no need to do anything because the whole case goes away. Now, the 11th Circuit can either accept it or reject it. The 11th Circuit granted it, and so now they are considering this appeal. And So standard of review is de novo, which just means they'll make their own decision. They don't give any deference to what the trial judge did. Now, if this was involving weighing the credibility of witnesses, things of that nature, they give a lot of deference to the trial judge. But here it's just a legal question. And so the court, again, in a very organized manner, says, look, first we're going to talk about TCPA. And then next we're going to talk about the standing requirements under Article 3 of the Constitution. And then we'll look at the actual allegations of the lawsuit here, look at our precedent in the 11th Circuit, which 11th Circuit is Florida, Georgia, Alabama. And then they'll look at what Congress has done. So let's start off with TCPA. So here's kind of the reason this came about. Residential telephone subscribers consider automated or pre-recorded telephone calls to be a nuisance and invasion of privacy. And so it says if you've got an automated telephone dialing system calling residential or cellular telephone lines without consent, that's going to be a violation. And also unsolicited advertisements via a fax machine. So back in the day, we called this the junk fax law. Okay, before everybody had cell phones, that's really what this most of the litigation was about. And then it says there's a private cause of action. So Congress has said if this law is violated, you can sue and get damages for this. And it can be incredible damages. We've had cases where 100 calls, 300, 400 calls, and you literally get out your calculator and say $500 or up to $1,500 per call. So incredibly powerful law. And then the court notes there's two updates. So in 92, it said the FCC can exempt free to receive cellular calls if it chooses to do so, which it has not. And the law has been silent as to text messaging because that didn't exist back in 91. And then it notes that the FCC has said we're going to apply this to text messages, and other courts have as well. And so the court says, look, just looking at the complaint, it appears to state a cause of action under the TCPA. So, Mr. Plaintiff, you're good there. But we have to take a step back and say, do you even have the power, the standing to open the doors of the federal courthouse? This is Article 3 standing. So the court notes that not every right created is automatically enforceable in federal courts. Federal courts are limited jurisdiction. So when we file a case in federal court, we have to prove we have the right to be there. That's different than in state court. In state court, you generally do not have to do that. It's a court that's automatically open, but federal court is limited. And so there's a quote here from Alexander Hamilton. Our three-party system of government says there's no liberty if the power of the judging is not separated from the legislative and executive power. So it's just what we learned back in civics or government class in high school. You've got the legislative branch that writes the laws, the executive branch which executes or enforces the laws, and then the judicial branch which decides legal issues. And so the court says we've got to make sure as a federal court that we stay within our lane, if you will. We stay within where the Constitution grants us power, which is Article 3. And so it says to federal courts, you have the power to decide cases and controversies. And so we've talked about this in other videos. I won't go into much depth, but it's just we don't give advisory opinions in federal court. In other words, a senator can't call a federal judge and say, would you write an opinion about this law I'm thinking about passing? Or a business owner can't go to a federal judge. She can't ask a federal judge, hey, I'm thinking about doing this. Will you tell me if this violates this law or if it's okay? Instead, federal judges wait till there's an actual case before them. And one part of this is the doctrine of standing. And so it says that's to preserve the judicial process from being used to usurp the powers of the political branches. So in other words, if judges just started writing articles saying, by the way, if Congress passes the XYZ law, it's no good. well, now you're kind of stepping into the role of Congress, and that's not proper. And so it says, even when it appears those other branches have given federal courts the power to do something, they still have to examine on their own to make sure that the federal court actually has this power. And so 3 elements to do this, and almost all of these cases involve the first element. An injury in fact. Number 2 is that you can trace the conduct of the defendant to that injury. And then number 3, that it can be redressed. So it's the first element that is in play in almost all of these cases. And so they say, look, the injury must be concrete. So here we have the Spokio decision, which we've talked about before. This was a Supreme Court decision involving the FCRA, Fair Credit Reporting Act. So an injury in fact must also be particularized, that is, affecting the plaintiff in personal and individual way. Now here it is, because the guy got a call or a text message on his cell phone, so he meets that. So going back to the text of the opinion, the concrete injury must be de facto, that is, it must actually exist. We're not talking about hypothetical or speculative. And now it doesn't have to be anything major. It says it can be identifiable trifle, okay? So it could be a $5 fine, a $1.50 poll tax. But then it warns us sometimes the intangible injuries are such that they cannot easily identify them. And so when it's difficult to recognize, then you look to the history and judgment of Congress for guidance. Again, that goes back to that Spokio decision. But just because Congress says, here's a right, and you have a right of action, in other words, you can sue, it does not automatically create standing. So it requires a concrete injury, even in the context of statutory violation. So stated another way, the requirement of an injury, in fact, is a hard floor. So it's a bare minimum for Article 3 jurisdiction that cannot be removed by statute. So they're saying, regardless of what statute says, like you have to have that injury in fact. So now they look at the 11th Circuit. Again, the 11th Circuit is the appellate court over all of the federal judges in Alabama, where I practice, in Georgia, and in Florida. And there are other circuits. You've got the 5th Circuit and the 1st Circuit and all the way up to the 11th Circuit and then a few other courts. And we're going to talk in this opinion about the 9th Circuit because they reached the complete opposite result of this case. And so we'll talk about what that means. Now they say, look, the plaintiff bears the burden of establishing this jurisdiction because remember, the plaintiff, the one that filed the lawsuit, is the one that says, I want the doors of the federal courthouse to open. Now, if you file in state court and a defendant removes you to federal court, there's different ways to look at it. One, you could say, well, the defendant bears that burden. A lot of judges would say, no, it's still the plaintiff. But if you don't meet it, you just go back to state court. Again, that's why I like to file these cases in state court. And so they go, because the plaintiff bears the burden, we look to the substance of his amended complaint to see if he has standing. So what did he say about this? And this reminds us, we've had other cases on this, this reminds us how important it is in our pleading that we get the pleading right. And we'll see a little bit of that in this case. So he says, one text message caused him to waste his time answering or otherwise addressing this message. While doing so, the plaintiff and his phone were unavailable for otherwise legitimate pursuits. And then he says it's an invasion of privacy and he didn't get to enjoy the full benefit of his cell phone. Now, if we go back, there's a footnote here that I want to just address briefly. It says a bare procedural violation of statute may result in no harm. And so Spokio, again, that Supreme Court decision, reaffirms proposition we must always look for concrete harm. And sometimes that's purely speculative and that's not going to be enough. So here's an 11th Circuit case, the city mortgage case. And while there was a violation of the law, they said that's not harm here. And then they say, let me just highlight the rest of this, but we should not ignore the Supreme Court's guidance in cases that purport to allege more than merely technical violation. This appeal presents a close question. In other words, are the allegations real? Are they concrete? Or are they just a figment of the imagination of the plaintiff? And so they say, look to the history and judgment of Congress, and that'll help us. So going back to the text here of the opinion. And they say, look, these are qualitatively different than other cases in the 11th Circuit that have found standing over one single violation of TCPA. So the Palm Beach Golf Center case is kind of a famous case in the 11th Circuit. And the person there got one junk fax. And the court said, that's enough. We find standing in that. Because during the minute or so it took to receive and process the fax, his fax machine was unavailable. And then you have this Florence Endocrine clinic, and they say, what about the cost of printing the unsolicited fax? Again, that shows standing. And so they're looking at tangible costs. So paper and ink, he didn't get that, right? In our case, he says the text message uses no paper, ink, or toner. And then it alleges generally that causes recipients to incur cost to their cell phone provider, but it doesn't say how that specifically applies to the plaintiff here and how the plaintiff's text actually cost him any money. So maybe it did and it just wasn't pled right, or maybe it really didn't, and that's why it's kind of pled in a general way. But if we move beyond the tangible costs, so remember tangible costs would be like the paper, the ink, the toner, and then we look at this more intangible costs. It says, you know, that has some similarities with the Palm Beach Golf. That's the unsolicited fax case. But they differ in kind, rendering Palm Beach inapplicable. So here we go back to the pleading. So at oral argument, the plaintiff said this was comparable to using a minute of my fax machine time, but his complaint doesn't say that. So they're not going to really address that argument because it wasn't actually in the complaint. Instead, the complaint just says there was a general waste of time. And so they say in the absence of a specific time allegation, in other words, was it 5 seconds? Was it 20 seconds? What was it? We decline to assume an equivalence to the facts of Palm Beach Golf when receiving a fax message is qualitatively different from receiving a text message. So what's their support for that? They say, well, a fax message consumes the receiving device entirely, while a text message doesn't. So this is the claim, and if it's different for this particular plaintiff, then this should be alleged in the lawsuit. A cell phone user can continue to use all the device's functions, including receiving other messages, while receiving that one text message. So it's different, it's what the court says, different than the fax machine. Now, I'll just say this. The fax machine, in my memory of that Palm Beach case, is it was a literal fax machine. So it wasn't like an e-fax. Okay, so I have an e-fax. I get faxes anywhere and it comes into my computer. So it might be a different result if, and I don't know with my e-fax if I can get multiple e-faxes at the same time. But what they're saying here is the cell phone, you can get multiple text messages at the same time. You can be using your maps. You can use your email. And if that's not true, in other words, if maybe getting that text message uses up your data or slows down or interrupts watching Netflix or whatever it is, then you've got to allege that in the complaint. Give the court something so the court can see, oh, this does interfere with your use of the cell phone. Okay, now the next thing is he makes an allegation about unavailability, but they say that too is distinct from Palm Beach. So they say has alleged no particular loss of opportunity. A fax machine, get that to highlight. Well, for some reason it's not wanting to highlight. A fax machine's inability to receive another message while processing a junk fax has no analogy with cell phones and text messaging. Again, the court may be wrong, but you've got to allege that. And they say it looks like what he's really doing is just copying the language from that Palm Beach and they can look past that just sort of conclusion here. So again, it tells us how important it is when we're alleging a lawsuit to put the very particular and fine details in there. And I'll say this. This is not what the rules of pleading tell us to do, but this is something particularly in the 11th Circuit that it's different than anywhere else in the country. I mean, you have got to plead your cases with great detail in the 11th Circuit. So whereas years ago our lawsuit might be 5 pages long, typically our lawsuits in federal court are 30, 40 pages long. And sometimes the defendants and frankly sometimes the judges kind of fuss at us about that. And we go, hey, you're the ones that tell us we got to have every detail in there. So you've got to choose. If you're going to hold us to the standard of putting in every detail, then nobody can complain about how long the lawsuit is. All right, so they say, look, Palm Beach doesn't help you. And they say this Ninth Circuit case that appears to hold the opposite of what the 11th Circuit's ruling, they say, we don't think they did a good job analyzing that case. So in that case, the Van Patten case, 2 unsolicited text messages constitute injury in fact. And so they say, since the 11th Circuit precedent, our own precedent, doesn't control, now we're going to look at the Supreme Court in the Spokio case. And what do they tell us to do? They say, look at the history and judgment of Congress and see what help that gives us. And they say that really gives no help. So let's look at the judgment of Congress. So, they say, let's start off and look, what does it say about telemarketing via text messages? Nothing. There's nothing in it. Okay. And they say the TCPA is completely silent on unsolicited text messages. Now, one reason is they didn't exist in 1991. And so Congress has amended several times without adding text messaging to the categories of restricted telemarketing. And then we do have a footnote, and they say, now we do understand the TCPA will be expressly doing this, expressly mentioning text messaging, but as of now, it doesn't. And so they say it's only through the rulemaking authority of the FCC voice call provisions have been extended text messages. At most, we could take silence as tacit approval of that agency, in other words, FCC. So what the court's saying here is, all right, Congress hasn't said anything, but Congress knows that the FCC, who it gave authority to regulate this, has extended it to text messages. And so at most or at best, we're going to say that they kind of approve. Now, I think it's a little stronger than that, but this is what the 11th Circuit says. And then they say, so you barely have anything there helping you, Mr. Plaintiff. But on the other hand, let's see what they find out about telemarketing. And that tells us, according to the court, that it's much, much different. So a concern for privacy within the sanctity of the home does not necessarily apply to text messaging. Unrestricted telemarketing can be intrusive invasion of privacy. Many consumers are outraged over the proliferation of intrusive nuisance calls to their homes from telemarketers. And one of the leading senators talks about, makes you want to just grab your phone, talking about a residential phone, and rip it out of the wall and throw it across the room. Okay? And they say, by contrast, cell phones are often taken outside the home, often have their ringer silenced. There's less potential for nuisance and home intrusion. Now, yes, you can silence it, but most people have it set up so when a text message comes in, it makes a noise, it flashes across your screen, depending on how you have your settings. It may permanently stay on your screen, if you have a lock screen, saying, hey, you have this text message, and you can read part of it. So I'm not sure the court is entirely accurate there. But it's saying, thus not surprising that the court found FCC should have flexibility to design different rules for these types of calls if they're not considered nuisance or invasion of privacy. And then it says you can exempt certain calls. And so here's what the court says. judgment of Congress is ambivalent at best. Its privacy and nuisance concerns about residential telemarketing are less clearly applicable to text messaging on a cell phone. And any possible deference to the FCC's interpretation is not obviously relevant, where the Supreme Court specifically instructed us to consider the judgment of Congress. Well, again, I think that's not entirely correct, because when Congress has delegated authority to an agency, then that agency, in essence, is acting on behalf of Congress. But what they say is congressional silence is a poor basis for extending federal jurisdiction to new types of harm. And then we see this is a very conservative approach here by the court. We take seriously the silence of that political branch best positioned to assess and articulate new harms from emerging technologies. So now they say, well, let's look at the judgment of Congress about the specific harm that the plaintiff says he suffered. And this footnote, by the way, you'll often see this, is called the Chevron deference. And it's just saying, how much deference do you give to an agency? Sometimes it's none, sometimes it's tremendous deference. And they say, we don't have to get into that here. So, we consider Congress, judgment of Congress when assessing standing, because Congress is well positioned to identify intangible harms that meet minimum Article 3 requirements. And so what was Congress concerned about? Intrusive invasion of privacies into the home. And so the plaintiff says, well, my particular privacy interest is freedom from unwanted robocalls, but they say that's too general. And then they say a single unwelcome text message will not always involve an intrusion into the privacy of a home in the same way that a voice call necessarily does. And then they say he hasn't alleged that he was at home when he received this message. And, probably was not. I mean, most of us, if we're working, if we're going to school, we're spending more time during kind of normal hours outside of the home. And then they say, because Congress told the FCC you're able to exempt free to receive calls, cell phones, even though they haven't, that suggests less congressional concern about calls to cell phones. And then because of their portability, their ability to be silenced, although, again, I think very few people silence all text messages, because the idea of a text message is somebody's trying to get you, maybe it's your spouse, a kid, a coworker, and generally people have some expectation to get a quicker response. So, most of us don't say, well, I'll check my text messages once a week or once a day. So generally people have their text message where it's going to make noise, but the court's saying because you have the ability to silence it, we think it's less intrusion. And they note, hey, Congress could not have seen the explosion in personal cell phone use. And they say, but we're supposed to look at the actual judgment, not imagine what Congress might say about a harm it's not actually addressed. And then they say, look, we understand this case reached the opposite result. And it's interesting, and I might do a video on that if anybody's interested. The Van Patten case basically cites the same things. Okay, so they say Congress power protecting consumers, unwanted intrusion. And then it says, but that court stopped short of examining whether isolated text messages not received at home come within the judgment of Congress. And instead, that court said Congress identified unsolicited contact. Okay, so both courts are looking at the same set of facts, if you will. Here's what Congress said and did. But the Ninth Circuit said, we gather from that the harm is unsolicited contact. And the 11th Circuit saying, no. We think it's unsolicited contact on your residential line when you're sitting in your house. That's what we're talking about. And so the court says, we disagree with the Ninth Circuit because we think it's a broad overgeneralization of the judgment of Congress. And we focused our analysis on text messaging specifically, which that's not what they say the Ninth Circuit did. And then they say, well, there's some other concerns. And they show that this doesn't help the plaintiff. So telemarketing Let's see, telemarketing by fax. It occupies the fax machine. It's unavailable for legitimate business messaging while processing and printing the junk fax. And they say that has no application to an instantaneous receipt of a text message. Again, I question that, and maybe the complaint could have been worded a little bit more specifically. I mean, was there a graphic that came with that text? Because it talks about it as a multimedia type text. Was it just words? Was it, the picture of a coupon? I mean, how long did it take? Now, if it just said 10% off, maybe that is instantaneous. But, some text messages are real long, and they might require multiple messages. But according to what the court's saying here, this was an instantaneous receipt. And then they just sort of summarize it here. The judgment of Congress provides little support for finding the allegations state a concrete injury in fact. And then they say there are other concerns not raised, like public safety, costs borne by consumers use technology avoid unwanted calls, commercial freedom of speech. And they say we're not getting into that. So now they look at the history. So remember, they've looked at the statute itself. They've looked at standing and said, well, what do we say in the 11th Circuit? No, it's not close enough to like those junk fax cases. And then they looked at the judgment of Congress. Now they're looking at the history here to see what happens from a historical viewpoint. And you may remember from another case we did, a lot of this is going to ultimately trace back to Justice Clarence Thomas. He wrote what's called a concurring opinion. We'll see a concurring opinion here. I think it's the first one we've done in our cases. A concurring opinion is where you say, I agree in the result, but maybe I disagree on how you get there. So I would take a different path to get to the same result. Or you say, I agree, but I want to point something out here just to clarify so nobody misreads this case. And that's what we'll see in this one. But Justice Thomas really goes into, we're looking for some parallel in the common law. And the common law just means not statutory law. But in other words, what could you do in England? What could you do in America in the 1700s, 1800s? So we have common law like negligence or fraud or invasion of privacy, defamation, slander, libel, that type of thing. And so they say, look, when you're looking for guidance on Article 3, to see if we have standing, consider whether an alleged intangible harm has a close relationship to harm that has traditionally been regarded as providing a basis for a lawsuit in English or American courts. And so they say, well, the plaintiff talks about invasion of privacy, so let's look at invasion of privacy. And so oftentimes this is called intrusion upon seclusion. So that creates liability for invasion of privacy for things that would be highly offensive to a reasonable person. And so they look at what's called the restatement second of tort. So the restatement is where a bunch of judges, academics, law professors, they get together and they sort of restate the law, trying to put forth sort of a national standard and say this is what the law is, and occasionally they say this is what the law should be. And so some of these restatements have a lot of support among Supreme Courts in different states, and others not so much. But this is one that does have a pretty good amount of support. Restatement of Tort Second, 652B. And so they say, look, that interference has to be substantial, strongly objectionable. So it's got to be objectively serious and universally condemnable. Okay? And now there is a comment that talks about phone calls where it's not just a couple phone calls, but it's such where it becomes the hounding of the plaintiff. Now, obviously, this could vary. I mean, is it, we talking 3 phone calls in 60 seconds? Well, that may be hounding. 3 phone calls over 3 days may not be. And they say, look, your allegations fall short of this harm. And we don't see this objectively intense interference with this isolated, momentary, ephemeral type of, you can't put it in your hands, okay? Now, You can also say we can't put a phone call in your hand, okay? But they're just saying, look, you get this text message, it came out of the ether and it appeared instantaneous in your phone call, so we don't see what the big deal is. And so again, kind of defining this intrusion upon the solitude or seclusion of another, his private affairs or concerns. And the plaintiff, rightfully so, made the argument, look, my cell phone is part of my private affairs. And the restatement is looking at all sorts of different things here, like eavesdropping, wiretapping, looking through personal documents. And they say, and that's the court saying, we understand you're saying it's private, but the restatement talks about these things that would be more like, snooping into your personal business. And they say one text message to a private cell phone is not this kind of meddling intrusion here. And the argument by the court is the plaintiff's reasoning would equate opening your private mail, which they go, that is a serious intrusion, with mailing you a postcard. Now, interesting that they say postcard, because the Fair Debt Collection Practices Act, the FDCPA that regulates debt collectors, talks about if a debt collector sends a postcard, that is a terrible violation of the FDCPA. And violations of the FDCPA traditionally are viewed in a similar manner as an invasion of privacy. Matter of fact, if you remember our video on the reason for the FDCPA, this is the very first section, 1692. It talks about abusive debt collection results in invasions of privacy. So I think the plaintiff had the better argument here than the court, but I'm not wearing the black robe, so this is what the court says. And then the plaintiff said, look, this is also a nuisance. And so they say, well, let's look at trespass and nuisance. Now, and we'll see what the court says, but I'll just tell you, typically a trespass is when you go onto somebody's property. And a nuisance is where you're not physically on their property, but you're impacting their ability. So walking across somebody's property would be a trespass. If you're belching smoke out of a factory and it's creating horrible smells, but nothing is physically entering your neighboring property, then that could be a nuisance. So we'll see what the court says here. So trespass requires intentionally entering the land in possession of another. A nuisance is a non-trespassory invasion of another's interest in the private use and enjoyment of land. So again, it's maybe there's horrible noise, smell, there's a pig farm next to your property, and so you're not able to use and enjoy your property. And they say, well, you haven't alleged any invasion of interest in real property, which I'm a little puzzled by that, because I'm sure the plaintiff never argued that. He's just saying, look, it's similar to this. A nuisance is when you can't use and enjoy your property. That's a similar violation to when I can't use and enjoy my personal private cell phone. And then the court says, well, even in nuisance to real property, the mere disturbance and annoyance as such does not necessarily give rise to invasion of legal right. And they just say, look, it's not similar to nuisance and trespass because you didn't allege it affected your real property. Again, I don't think that's what the plaintiff was arguing. He's just saying, guys, look, it's similar to a nuisance. And that's one thing in Justice Thomas's concurring opinion where he's talking about it doesn't have to be an exact parallel. It's just you're looking to see, is this similar? And frankly, the 11th Circuit, in a case involving the Fair Credit Reporting Act where too many digits of your receipt with your credit card were printed out, they said, well, that's like an invasion of privacy or like another common law type thing. So I'm a little surprised the 11th Circuit has taken this approach. And then the plaintiff says, well, look at conversion and trespass to chattel. So conversion is typically where you take my personal property and I can't use it. So you steal my car, you steal my phone, whatever it is. A trespass to chattel is very similar. At least in Alabama, we typically just consider those to be one and the same. Let's see what the court says. So conversion is an interference with chattel. Chattel just means not real property. Chattel which is so seriously interferes with the right of another to control it, the actor may justly be required to pay the other the full value. So again, you take my car, okay? I can't use it, so you should have to pay me for my car. Now, it doesn't mean that if you take my car for 10 minutes, the test is whether you owe me the full value of the car. The test is just, did you deprive me of my use of it? And then the jury will decide the damages. And they say, allegations are nowhere near a complete and permanent dominion over his phone, so that's unhelpful. Again, I would say it doesn't require complete and utter dominion. It just requires somebody has taken away your ability to use that property. And so again, I question whether the court has gotten that exactly right here, at least the way that we use this in Alabama. And so, let's see what else they say. Traditionally, liability arises kind of trespass only when the possessor is deprived of the use of chattel for substantial time or materially or harms materially valuable interests and physical condition. Now, I will agree here that, the amount of time taken up by a text message typically is not going to be that much. And so I would agree it's not a conversion, but the question is not, is it literally a conversion? The test is, does it bear some relationship to a recognized harm? And I should have said this before. Here's why we're doing all this historical stuff. Because the court says, well, if you could bring a case involving a historical cause of action, like trespass to chattel, conversion, invasion of privacy, trespass to real property, negligence, well, since you could traditionally bring those, we're going to assume that those must meet the definition of a case or controversy, because when the Constitution came about and said you can decide, federal judges, you can decide a case or controversy, they had to mean those things that people were routinely bringing in court, like negligence, trespass to chattel, trespass to real property, nuisance, etc. So that's why we're looking at this stuff. So it's not saying, do you meet the exact requirements for conversion or nuisance or whatever it is. It's, does it have a relationship to it such that we can say, well, if you could bring an invasion of privacy claim and here's a new statutory right, it's similar enough that we're going to say that opens the door to the federal courthouse. So let's see what the court says here. Traditionally required physical touching, and they say it bears a passing resemblance. They differ so significantly, undermine his position, and they say this kind of fleeting infraction that tort laws resisted addressing. And again, they may be right with that, but the question is, does it bear enough of a resemblance that it tells us this is something that should open the doors to the courthouse? And I think I will go back and I'll address that, what we sometimes call a truncation case, where they don't limit your credit card digits, and that violates the Fair Credit Reporting Act, because you'll see, I think it's a different approach here, or if it's not, it's a very fine line trying to distinguish these two cases. And I'll just say this now. What the U.S. Supreme Court often does is they wait until there's multiple circuits that have differing opinions, and then they'll step in to resolve it. And even within a circuit, so the 11th Circuit here, this panel of judges could decide this case again and reach the opposite result. Or the plaintiff may say, I want the entire 11th Circuit to hear this case. That would be called a rehearing en banc. It just means the entire court. And they could decide it differently. And so they say, we note again, our sister circuit, that's the 9th Circuit, has reached the opposite conclusion. And they say, we just disagree. And here's what the 9th Circuit said. Actions to remedy defendants' invasions of privacy, intrusion upon seclusion, and nuisance have long been heard in American courts, and the right of privacy is recognized by most states. So again, that's what I'm talking about. You're looking to see, in essence, when the federal courts were created, could they have heard a case involving invasion of privacy, nuisance, etc.? And the Ninth Circuit says yes, so therefore they can hear this. The 11th Circuit says no, this is not closely related enough. And they say we more thoroughly explained. An examination of those torts reveal significant differences in the kind and degree of harm they contemplate providing redress for. And so in summary, we find the history of the law, the common law, and the judgment of Congress do not support finding concrete injury here. And I do want to drop down and address this footnote because there's a case in the 11th Circuit called Perry versus Cable News Network. And there's a federal law called the Video Privacy Protection Act. And so the plaintiff sued under that. And this is a recent case, 2017. And it said, Perry held the plaintiff's allegations in the 1980s era statute involved precisely the same substantive privacy right, not so here. And they say the judgment of Congress and history revealed that there's just not a concern over a single text message to a cell phone. And so they say plaintiff hasn't alleged anything like enjoying dinner at home with his family, having domestic peace shattered by the ringing of the telephone. That comes from, like I'm saying, one of the senators talked about, these calls come in dinner time, you just want to rip your phone out of the wall. And then they say he didn't allege his cell phone was searched or taken away from him or seized for any length of time. And it's this brief, inconsequential annoyance, and that is very distinct. And the chirp, buzz, or blink of a cell phone receiving a single text message is more akin to walking down a busy sidewalk and having a flyer briefly waved in one's face. And what they're talking about there is, it's probably just a typo there in how they spell the word wave, but it's just saying that's not enough for you to sue over. And now they don't give any support for that. There may be a case that says that, but, I think there's a different way of approaching this, which is saying, hey, the Congress has said this is really important, these annoying auto dial calls, because this call or this text that came in was not somebody just typing a text. There's no prohibition or TCPA for that. It's when it's an automated text that's sent out and there hasn't been consent provided. So I think it's a little different than having a flyer waved in front of your face. But the court says, again, these are the guys with the federal robes or with the black robes. They say annoying perhaps, but not a basis for invoking jurisdiction. And so they say it does not state a concrete harm. And they recognize there's a problem here, or an argument that can be made against this opinion. And they say, look, we're not attempting to measure how small or large his alleged injury is. Article 3 standing is not, you must be this tall to ride type measuring stick. There's no minimum quantitative limit required to show injury. Rather, it's a qualitative nature of the injury. And so they are very quick to point out, and we'll see this particularly with the concurring opinion, our assessment today is thus qualitative, not quantitative. So they would argue, or at least the defendants, trust me, will be arguing based on this case that, well, see, it's qualitative, not quantitative. So, yeah, we sent you 10 text messages. Well, that's just quantitative. I mean, that's just adding up numbers here. And so it should be the same result. 100 text messages, 1,000 text messages. Now, we'll see the concurring judge, she's not buying that, or he's not buying that. I forget who it is. But the majority opinion here is saying it's qualitative, not quantitative. And we've assessed how concrete and real the alleged harm is. It's not the kind of harm constitutes injury in fact. But then it's interesting, the harm he suffered from receiving a single text message. Now, they seem to be emphasizing single, but yet they say it's not quantitative, only qualitative. To be sure, under our precedent, allegations of wasted time can be the harm. So time wasted traveling to the registrar's office. County registrars would be like probate type court or tax authority. Correcting credit reporting errors. So this is under the Fair Credit Reporting Act. And they say the concrete harm must be more than a few seconds. And then they say, well, look, the FCC says that under telemarketing standards, releasing the call party's line within 5 seconds of a hang-up, demonstrating that on the margin, Congress does not view tying up a phone line for 5 seconds as a serious intrusion. And so they say our responsibility is to look at statute, our precedent, in other words, the 11th Circuit, history, and the judgment of Congress. And then they say, look, it's going to have different outcomes based on the information that you plug into that formula. So Perry, remember that's the FCRA, Palm Beach is the TCPA. The city mortgage, if I remember right, and you'll notice this is an en banc hearing, so the entire 11th Circuit. I think that was under RESPA, or Truth in Lending, but I'm not sure. I'd have to go back and look at it. And says there's no harm. In other words, it was just speculative. And they say we acknowledge that Congress is well positioned to assess new harms, and they can do that, but we are not. So we only have the power to say what the law is. This goes back to every law student studies this probably the first case in constitutional law, Marbury versus Madison. And they say when the plaintiff comes to us without alleging concrete harm, a real injury states case controversy, we cannot even do that much. And so here's the Jill Pryor is concurring in the judgment only. So she says, you reached the right result, but I do not agree with how you got there. And so single text, unwanted text message advertisement, lack jurisdiction, no standing. And so Judge Pryor, why are you writing this? To emphasize my understanding the majority's holding is narrow. And conclusion that lack standing is driven by the allegations that sent only one text message. The majority opinion, appropriately in my view, leaves unaddressed whether plaintiff who has received multiple unwanted unsolicited text messages may have standing. With this understanding, I concur in the majority. So she's saying, I want to make this very clear. We are not reaching the decision of what if you had 2 messages or 10 or 20. It's just one. Now, I think the majority at least strongly suggested that if you had 2 or 5 or 10, that would make a bit of difference. But Judge Pryor here is saying, I do think that makes a difference. So I'll say this. This is why I've been spending some time on some of these cases where it talks about standing. It's sort of this obscure, sort of bizarre thing. But it's important because your entire case goes away. Now, this one, fortunately, was lost at the beginning, and so the plaintiff could go refile this. Now, there's 4-year statute of limitation for TCPA. I think the text was in 2016. Let's see. Let me scroll back to the facts here. August 12, 2016. So, the question is going to be, do you continue to pursue the appeal or do you file it in state court? And they may have another plaintiff that could file in state court. And then either you rock and roll with that in Florida and the defendant leaves it in state court, or they remove it to federal court, and then if they get you kicked out on standing, you go right back to Florida state court. But you could have this come up in the middle of trial after years and years of working on a case, and a judge says, oh, I just figured out I don't have standing. Case is gone. What do you do then? You're out the creek. So again, this is why on these federal statutory cases, we personally file these in state court so that we don't have to deal with this argument. And we've sort of been like a voice crying in the wilderness, and people say, oh, you guys are crazy, you're overreacting to this. But what we see in this case, I think, will be more common as judges are saying, hey, I don't have any authority to let you in the courthouse into this case, and I'm kicking you out. So obviously, when we do our cases, we do them the best way we know how. If you're doing this, or for the lawyers watching this, who are filing cases, you make your own decision. But this, I think, is a big warning. Even if it gets reversed by the 11th Circuit, or even if the Supreme Court takes it up, it just shows you these guys are always going to attack standing. And it's just sort of a never-ending battle. And again, I look at it and say, why take a chance? why take a chance with it? So hope that you found this helpful, and I have no idea how long we've been going. It's probably a long time, so if you're still with me, thanks for sticking with me this long, and we'll do more of these cases and also do some short videos as well. And as always, I appreciate your comments and questions, and I'll have a link to this. Hopefully you can see it up here at the top of the screen, but I'll put a link where you can go pull this directly from the 11th Circuit. And I'll catch you guys in the next video. If you have any questions, if it's kind of a private question, I mean, reach out to me directly, alabamaconsumer.com or 205-879-2447. But it's just a general question or comment or suggestions, or totally disagree with me, that's fine too. Just put it in the comments below, and I'll catch you in the next one. Thanks, guys. Bye.